I'm showing a 11:03, so why don't we go ahead and get started? I'll just start with some introductions. So for those of you who don't know, I'm Dan Prue. I'm the General Manager of the Greater Vernon Chamber of Commerce, and pleased to be joined today for our webinar with Veronica Ukrainetz from Ukrainetz Workplace Law Group. So pleased to have you here today, and Veronica brings a lot of experience and expertise to us, so we're very pleased to have her to share that with us. I'll let you know a little bit about Veronica. So she is the principal of Ukrainetz Workplace Law Group, and which was established in 2007. Veronica has practiced management side labor, employment, and workplace-related human rights and privacy law for over 20 years. And today, I think this topic is fairly specific. We're dealing with juggling family obligations in the workplace, which has obviously been exacerbated by COVID. So yeah, I will turn that over to you, Veronica, and feel free to take it away. Thanks again.
Thanks, Dan. In terms of questions, many of you know me, and and so many of you have attended my presentations, and you know my style. I'm happy to take questions through the chat or Q&A. Dan's going to moderate that, so we're not ignoring your questions. Some of them may get addressed as we work our way through this, and others will address specifically. So hopefully there's time at the end to address this. The hope was that Pamela could also attend. And many of you, again, also know Pamela. She had a family obligation. And so I needed to accommodate that family obligation. And so unfortunately, last minute, she was unable to attend. But we've got her. If I can advance these slides, you've got her face there for those of you that don't know Pamela. So our firm is based out of the Okanagan, but we support clients throughout British Columbia. We dance around the Lower Mainland, actually. Most Lower Mainland-based businesses end up dealing with Lower Mainland lawyers, but we'll deal with clients on the Sunshine Coast, on the island, up north. We found that clients that work and live in smaller communities tend to morph over to us. I think both Pamela and I living in Vernon, and then I grew up in Calgary when it was much smaller, and Pamela grew up in Fernie. We have this understanding of the dynamics of a smaller community. And so a little bit about our firm. Again, many of you know us. We basically provide parallel support to what a human resources manager or consultant would provide. And we actually work closely with a lot of HR personnel. And where we see our clients need that support, we refer out to HR personnel. But we'll support you with basically the entire continuum of the employment relationship. And the sooner you call an employment lawyer if there's an issue, or an HR consultant, the better. This topic today is specific to family obligations. We tried not to make it COVID specific. I think there's a lot of COVID burnout, even on what's the law around COVID, and now we're well into it for a year. And I was telling this to Dan, most of my clients seem to have a handle on what to do when there's an opening, a closure, a restriction, a work from home recommendation, and various orders and things like that. But where we are finding pre-COVID, during COVID, and now continuing, is the ongoing tension that employers have in trying to get employees to stay focused on work, attending work, being productive at work, while employees are also being pulled by family obligations. That's been enhanced by COVID, and that's been enhanced also by many remote working arrangements where employers are feeling that because there's provincial health orders making recommendations for remote work arrangements, that they must accommodate those. They must have employees working remotely, even if it actually isn't workable. Or employees finding themselves unable to be in the office because they're dealing with enhanced family obligations, kids being kept home just over the sniffles and things like that. And so the purpose of this presentation is to help everyone understand when there's an issue you must respond to and must accommodate, and when there's a family related issue that there might be some tension around it, but you don't actually have to do what the employee is asking. And frankly, you rarely have to do what the employee is asking. If an employee is asking for some accommodation around a family obligation, the best thing to do is engage in a conversation so that you can make an informed assessment as to what needs to be done to accommodate that obligation. So I'm going to start with different areas of legislation. Now, the Employment Standards Act of British Columbia is the baseline for all employers, unless you have an employee that is exempted entirely from the application of the Employment Standards Act. And there are employees that are exempted. Lawyers are exempted, poor Pamela, realtors, licensed insurance advisors. And so there are groups of employees that are exempted from the Employment Standards Act. And but the general default should be to assume that the Employment Standards Act applies. And again, a conversation with HR or legal or poking around the Employment Standards Act regulations might help you identify if you have some specialist type employees and whether whether the act applies. So the Employment Standards Act spells out leave requirements. And I will get into human rights later, but I do want to point out here too that even if the Employment Standards Act doesn't apply to the type of employee you're dealing with or the category of employee you're dealing with, typically human rights is the default and requires that there be some bending, accommodation, and flexibility. So it isn't necessarily a full answer to say, well, the Employment Standards Act doesn't apply to you. I don't have to grant you any leave to accommodate your family, because human rights requires accommodation. So I will deal with that next. So the Employment Standards Act does have a requirement that employers must permit employees to take a leave of absence for specific reasons. So the leaves are unpaid so far. We've heard talk in the province of making certain leaves paid, some medical leaves or personal leaves. So far, that hasn't happened. CLC is short form for the Canada Labour Code. If any of you are regulated under the Canada Labour Code, that's generally First Nations bands, although sometimes some components of First Nations are not regulated by the Canada Labour Code. Transportation, so locally here, organizations like DCT Chambers, they're a transportation organization that cross borders, they'd be regulated by the Canada Labour Code. So the leaves parallel in almost all legislation across Canada, but the Canada Labour Code did recently implement a 3 days paid personal leave. So the one paying is the employer, and it's a personal leave which has a laundry list of reasons a person can take 3 days paid, which includes some sick leave components and family leave components. Now, the leave requirements are that so A, the employer has to permit the employee to take the time off. B, employment is considered continuous. So for purposes of determining service-based entitlements in your organization, you can't pause the employee's calculation of their total duration of employment because, say, they went on a maternity parental leave for 18 months. Those 18 months are still included in your calculation of total service. And the last general criteria around employment standards leaves is that the employee has job protection. So their job is protected and they're entitled to come back to it or one like it. I have given some links here. For the most part on this presentation, I'm not going to click into the links, but they are available, and that will link you to fact sheets or the legislation. Now, the types of leaves, there is a long list, and this is a little difficult to read, but that link I gave you does give the list. You'll see that for the most part, these leaves are family related, and sometimes in a very negative fashion, such as a leave respecting domestic or sexual violence. Now, it's unlikely your employee is going to come to you and say, I got beat up by my spouse, I need to go on leave. But there is a mandate that the employee is entitled to take a leave for a stipulated period of time. It's unpaid if they experience any of what's going on here. And so the leave that was recently added, which I addressed in a previous chamber seminar, was the COVID-19 leave. And there are specifics around an employee's entitlement to take leave for COVID-related purposes. So the employee doesn't get to determine those specifics. However, it is a very broadly based characterization for the reasons an employee can take leave. Probably the only non-family based reasons come out in reservist leave and jury duty leave. So those are your types of leave. It's a long list. Just to revisit the leave protection and what it means. There's often confusion around that. Continuous employment. The Employment Standards Act, and this is where we get a little bit of confusion. It does say that an employee is entitled to any wage or benefit increases, which they would normally receive, but for the leave. And so it doesn't mean your employee gets paid while they're on leave, but what it means is if that employee had not been on leave and there was actively at work and would have been entitled to an increase in pay, you don't get to not increase their pay because they took the leave. And so the employee comes back with an increase in pay if that was something you would otherwise have awarded. You must continue to make payments to benefit and pension plans. Now, here's the caveat, provided the employee pays their portion. So this is an area where, again, I've seen sadly some of my clients get into trouble. It's a hassle. Often an employee goes on a leave, particularly a long leave, and communication stops, and the employer stops the benefits plan. And so there is an obligation to reach out to the employee and tell them, hey, we haven't got your employee portion of the benefits. And so if you don't pay that, we're going to terminate your benefits. So you're probably going to have to suck up a month or two of the employer covering that cost. It's a debt the employee will have to the employer. But there is an obligation to do some reach out to the employee before you terminate from the benefits plan. And just because it's a pain to continue an employee on the benefits plan doesn't mean you can't, or the pension plan. You must continue their participation in those plans. And then the last one, and this is where I see confusion, sorry, I clicked, is over the vacation. It's, again, the requirement is to continue to calculate length of service-based entitlements as though the employee had not taken the leave. So the challenge I often get employers facing, and the question they ask me is, they'll say, well, my employees come back from leave and now they want their vacation pay. And so I'll use maternity parental leave as the example, because that's the longest leave, although COVID leave has no outside. So COVID leave could potentially be a longer leave than maternity parental leave. But a combined maternity parental leave is currently around 18 months, and there is some ability to extend that. And so I'll have clients saying, well, now my employee wants roughly 2 years of vacation pay because they were on leave for 18 months. They're coming back and they're saying, pay me my vacation pay. So what the Act is saying is, no, it isn't an entitlement to vacation pay. It's an entitlement to have your entire duration of employment, including the time on leave, counted for the purpose of determining whether you're at 2 weeks vacation, 3 weeks vacation, 4 weeks vacation, or whatever your policy is. The Employment Standards Act caps vacation at 3 weeks after 5 years, but many employer policies are more generous. So if you're saying to employees after 5 years employment, you increase to 3 weeks vacation, which is the minimum, so you should be saying that, and an employee for 18 months of that was on maternity parental leave, or for 2 years of that was on COVID leave, you still count that time for the purpose of saying you've hit the 5-year mark, you're now at a 3-week vacation entitlement. As long as your policies or your vacation practices are paying vacation pay based on an accrual basis, we pay a percentage of wages. You don't have to pay vacation pay to somebody for their leave period. If your policy or practice is to say, I give everyone 2 weeks paid vacation, you could find yourself facing an employment standards complaint by an employee saying, I was off on leave for 18 months. During that time, I accrued 4 weeks paid vacation, because it's not a percentage of wages. So it's really important that you distinguish between those, and that vacation pay be paid out as a percentage of wages, or you are paying out vacation pay for an employee for a period of time that they were on leave. Now, job protection. I get a lot of questions about this where my client's like, well, I hired the replacement and the replacement's fantastic. Or while the person was on leave, we sprinkled the job out to a whole bunch of other people. We didn't even hire a replacement, and we don't need that person. Or while the person was on leave, we discovered all sorts of errors and omissions, and we don't want to bring the person back. Now, under the Employment Standards Act, the entitlement is to return to their job or one like it. And then there is a second requirement that says the employer cannot terminate or change job conditions without the employee's written agreement. This is actually a little known provision. And so this is absent another form of reorganization. And so what this is saying is that you can't say to the employee, well, you're coming back to your job, but we've decided to take away these 6 components of your job. You're not doing that, somebody else is doing that. Unless they agree, they come back to the job as is when they left it. And the challenge with that commitment is, again, the longer the leaves are, the more likely your workplace has changed. It's not a static workplace. So there is a little out, and that is if the job no longer exists and there is no similar job, the employee who is ready to return can be dismissed or laid off. But of course, you have requirements to pay severance pay. You don't get relieved of that. And so if the employer has reorganized, eliminated the job, it doesn't exist, or is reorganized and parceled out the job to multiple other people, or reorganized and hasn't even got a similar job, then you're okay to move forward. You're okay, but don't think you might not get a complaint. You may still get a complaint under the Employment Standards Act alleging that you failed to meet this. And one of the motivating factors for an employee to complain is that while they're on leave, they qualify for EI for many of the leaves, but not all, but most of them. But the problem is they won't qualify for EI if you then terminate. And so because they've utilized, in most cases, their EI entitlement, not all. Like if an employee takes a bereavement leave or a compassionate leave, that has a shorter EI duration than their total EI. But you might find that the employees they're pretty desperate because they've utilized their EI. They've now found themselves in a layoff or termination position, and there's no further EI eligibility. And so that's what often drives the employment standards complaints, even if you pay severance pay, is it's desperation. So what I recommend, and you're going to hear this throughout this presentation, is that you have conversations with the employee. So you've got people on leave. They're out of sight, but they should not be out of mind. And so it's important, if an employee's on leave and your organization is reorganizing, their jobs being eliminated, that you be in communication with that person so that they don't feel like they've been discarded just because they took the leave. Or you're also going to face a human rights complaint if they feel discarded by virtue of taking the leave. So it's really important, if you're looking ahead and you're seeing changes to that person's job, or possibly it may no longer exist and nothing else is available, that you be in communication with that person. If you're seeing drastic errors and omissions, if you're seeing problems, potential theft, it's important you address that so the employee has some heads up and perhaps might run the other way and save you terminating. So conversations are important. Now, over to COVID and the impact of provincial health orders on leaves. And so again, it is crucial that employers understand when they're having conversations with employees about employees going on leave or modified work arrangements or remote work arrangements, that you understand the difference between a provincial health order, which is also the terminology restriction is being used interchangeably with order, and a provincial health recommendation. Because a recommendation, it's not an order that's subject to penalties. It's a broad stroke recommendation, and employers need to look at those recommendations in the context of their workplace. And again, I've given you the link to the current provincial health order. I'm actually going to click on that one. And so you'll see this provincial health order, province-wide restrictions. It's not even called a PHO. It's called province-wide restrictions. Now, the restrictions again, are explaining that we've got some made under the Office of the Provincial Health Officer, others are made under the Emergency Program Act. So, Bonnie doesn't take the blame for all of the restrictions, all the PHO restrictions. So they're also called restrictions because they're not just PHOs. They're also EPAs, Emergency Program Act restrictions. And so this is a really good link for you to have bookmarked, because it'll allow you to keep up to date, because some of these impact your employees, some of these of course impact your services, but like the PHO on gatherings and events, that's an order. And so that'll impact social events within your workplace or even workplace meetings and how you're going to manage them. And so we've got safety recommendations. So currently there's a strong recommendation to work from home whenever possible, unless it's essential to be in the workplace. It is not mandated. I'm having clients come to me, keep in mind I'm management side. So what I always get is what the employer's doing in or dealing with in terms of their employee or multiple employee requests, is that I have clients facing assertive employees saying, I must work from home. It's a provincial health order. I have to work from home and you have to accommodate that. So this is why it's important that you know whether it's an order or a restriction or a recommendation, because then you can have a conversation about, well, actually not. And in our workplace, we've got enough protocols in place and safety protocols in place that you can still continue coming to work, and we're requiring you to come to work. So again, the conversation is best rather than a mandate. But it is important that you be aware of this, so that the tail isn't wagging the dog. The employee isn't dictating their terms and conditions of employment to you. The province can dictate it, but the employees don't. So, but it is important if you're having employees not working from home wherever possible. So that's important too, whenever possible. It might not be possible to have a productive employee working at home given the nature of the work or the nature of their work from home environment. And so you need to look at that. If it's essential to be in the workplace, you've got WorkSafe BC requirements that intersect with provincial health orders and restrictions in terms of making sure the workplace is a safe place to work. So that segues us over to remote work and health and safety issues coming out of remote work. As I've said, it's not an entitlement to work remotely. I'm getting employers facing a lot of pushback by employees about demands to work remotely. Although I do have to say that is teetering off as this pandemic continues and we get pandemic exhaustion. A lot of people are missing coming back to work. They're missing the connectivity, they're missing the collegiality, they're missing the social breaks. They're not liking being in their home, like keeping an eye on the washing machine or kids coming bursting in at 2:30, 3 o'clock from school. So it's and people are starting to feel quite isolated. So I am seeing, I guess, different forms of pushback now. Again, people that are more worried about COVID to the point of being paranoid and extreme in their concerns. And I don't want to say they're unduly or irrationally paranoid, because it may be that they haven't disclosed to you that they have underlying conditions. So we're seeing the people either people that are consumed with not wanting to, by any way, shape, or form, be exposed to COVID, demanding remote work. Other people that were looking for remote work and have been struggling with that, if they can get to the office, are often preferring to be in the office now. And again, we have a lot of tension around childcare around that. But it's not an entitlement unless it's ordered, and it's not currently ordered. It's not an entitlement unless there's a valid human rights-based reason for accommodating a work from home arrangement, and I'm going to deal with that next. And lastly, it's not an entitlement unless it's feasible, because remember, this provincial health order was whenever possible. So if it's not possible, the person doesn't get to work from home. So that may mean the person's not working at all. and then they're on a leave of absence, and their situation might bring them under the criteria that needs to be met under the Employment Standards Act for a COVID leave. And I have addressed those in a previous seminar, so I'm not reviewing those specific criteria for a COVID leave under the Employment Standards Act. In this seminar, I wanted to get over to human rights because my previous seminar focused on the Employment Standards Act. So keep in mind, you've got health and safety responsibilities, some of which are almost impossible for an employer to ensure are being met. But unfortunately, by allowing people to work remotely from home or following a strong recommendation, what flows from that is the same obligation for a safe and healthy workplace that you have in the workplace you can control in your own working environment. And so WorkSafe BC has scrambled to develop their expectations and protocols about employees working remotely and working from home. And even within that are protocols about employees working alone. They've always had those protocols, which usually dealt with like the all-night gas station attendant or the all-night 7-Eleven attendant. And so now we have, well, employers are saying, well, do I have to inquire? Are you working at home alone? Because if you are, you have to have check-ins built in and all these other things. And is the employee really working at home alone if, you know, it's only from 8:30 till 2:30 when the kids are home, because they're not working at home alone anymore once the kids are around, or if you know, hubby's coming home for lunch and things like that. So it is worth going into the link and looking at the guidance that's being given by WorkSafe BC for health and safety requirements, and it's a long list. And so I've also been asked, well, does that mean we have to go into an employee's home and review their workplace? I would say you have the ability to require, if you want to say, we need to come into your home and go to your work space, which might not be a dedicated office, it may be a workspace, to ensure it's meeting health and safety requirements. And yes, if the employer is making certain requirements, even if they're driven by WorkSafe BC, the employer should probably assume they're paying for those requirements. And so the WorkSafe BC link talks about developing a work from home health and safety responsibility, key requirements, reporting workplace injuries, duty to follow safe procedures. And then they've actually got definition of working alone. So if you further click on that link, you'll get to that. Procedures for checking in the well-being of workers. So I do have one client that's put a policy. It's a financial institution and they have employees working from home, and they've put the responsibility over to the employees to say, if you're home alone, there is a requirement that you check in with your manager every X hours. So having followed this rather than them nagging the employee to find out, they put the responsibility over there. And then the links also talk about ergonomic assessments, control measures, and part of the checklist is where there is a checklist, if you click on the links further on just what the actual work environment should look like. You know, they should have a fire extinguisher. You need to make sure they're not tripping over cords. The employees, have you asked them what they're going to do? You know, if there's a home invasion, if someone comes to the door, what's their own violence prevention and health and safety, you know, risk prevention plan. So it is fairly intensive, but it's worth having a look at to see what you need to address. That also flushes out, is it feasible for the employee to work from home? If you've determined that it's impossible or virtually impossible, except at massive cost, for the employee to work from home safely, you might decide you're not permitting that. Again, the conversation is best in addressing that. Now I want to move over to human rights. Dan, are we okay with questions or?
Yeah, so far we're okay for questions. It's a good time, obviously, to remind people if they do have questions, they can submit those via the chat or the Q&A, and I will help moderate those.
Thank you. So on the human rights, and this is an area where I wanted to focus because as I said in my previous seminar, I had a higher focus on employment standards. We are seeing a constant evolution about this issue of when is it a human right that such that the employee is making a family related demand or request, and when is that considered a human right such that the employer must bend and flex to accommodate that. So the challenge I find often clients face is this whole area is difficult, and it's frankly it's difficult for employment lawyers also. It's an evolving area. And and I think some of the decisions that are coming out now, 5 years from now even, would have been decided differently. So this is not where I can tell you, like the Employment Standards Act leaves black and white, you must grant a leave in this circumstance. So there needs to be a lot of conversation with an employee around these issues. So the status of family status is a protected ground in human rights. So our Human Rights Code in British Columbia says thou shalt not discriminate based on religion, sex, disability, blah, 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 including family status. So there's a whole list. And now the legislation in either the BC Human Rights Code, or if you're federally regulated, so if you've come under the Canada Labour Code, you're coming under the Canadian Human Rights Act, there's no actual definition. So even the definition of what is family is evolving and changing. And so we're going to see decisions change around that. And this is where we see a lot of kind of morality, religion, and people's views coming into play into, well, how can they saying this is a family issue? You know, you're saying you you have a family comprised of your child has two mothers and one father, and it's not a separated family. It's a family that all lives in one home and things like that. So this is where we're going to see that employers struggle because they might have difficulty given where they come from, their own moral beliefs or religious beliefs, in accommodating some of employee requests. So there is a definition of a family relationship. So, but not what is family status. So, a family type relationship, again, broad definition, family are spouses. And there's questions, are they ex-spouses? Answer no, but they are spouses. And those living in a spousal-like relationship. Parent and children, including adult children. So we get extensions from that. Does that include stepchildren? Does that include biological children, adoptive children? Siblings, which is also step siblings or non-step siblings, in-laws, uncles, aunts, nephews, nieces, cousins. So we basically have the generally accepted extended family. And then this umbrella phrase, those living in a family type relationship. So you might have an employee who's taken in a child in an informal foster type relationship. My neighbor's 12-year-old keeps running away from home. They've asked me to help out, so I've agreed the 12-year-old can live at my home for the next 3 to 6 months while they try to sort out what's going on, and that way then they're still close. Well, is that child now living in a family type relationship? And so again, that might be where you're questioning your employee's generosity, because now the stressors of dealing with a runaway are something your employee is dealing with. So this also addresses common law type relationships. It can address more, unusual LGBTQ type relationships and things like that. And so it is fairly broad. So part of the tension in the conversation you're going to have with employees is they might not want to talk to you about the nature of that relationship because it's none of your business. But if they're looking for some sort of accommodation, you are entitled to make inquiry and find out, like, are you living together as a family? Or is your girlfriend, boyfriend actually in their own home? Now, when must you accommodate somebody who is saying, I have a family related issue, this is what I need, and you must bend? And so this is where I'm saying we're getting more and more cases. So unfortunately, we don't have a black and white answer. But this phrase has been the application of the law that has been supported for about 15 years now, but it's very contextual. Applying this to certain circumstances is changing. So in an employment context, if an employer requirement, it might be a policy, it might be a direction, it might be a practice, has a serious interference. So again, it needs to be a serious interference. So you can see the need for the conversation. Is an employee saying this is inconvenient, or are they saying this is a serious interference? It's impacting, and so none of these stand alone. It's impacting a substantial parental or other family duty or obligation. So if your requirement is seriously interfering with your employee's ability to take their kid to ringette, you're going to say, okay, I have an employer requirement. I have a serious interference. They can't get the kid to ringette, and dad isn't available to take them either, or vice versa, nor a neighbor. Then your question is that a substantial parental or other family duty or obligation? And this is where we can get into some arm wrestling over people's philosophies about parenting, their ethics around parenting, when they see something as substantial. Some parents are passionate that extracurricular activities are just fundamental to the health and well-being of their children. So they're saying, this is substantial. It's important to my child's health and well-being. And so yeah, you must accommodate this. The law currently, just so you know, says extracurricular activities don't count as substantial parental or other family duties or obligations. And so where all three of these requirements are met, the employer has an obligation to take steps to give relief from the adverse effects. And so the legal terminology is accommodate to the point of undue hardship. So, which is a whole nother set of questions. What's undue hardship? This doesn't mean you have to give the employee what they're demanding. It means you have a conversation. And so the employee, might be demanding that for whatever reason, they not work Mondays and Fridays because the employee, there's a family related commitment Mondays and Fridays. So to use another example, it might be, well, I need to take my aging mother to medical appointments to a specialist on Mondays and Fridays, or to adult daycare. I need to take my parent who's experiencing dementia to adult daycare, and their days are Mondays and Fridays. Now, I often see employers being a little suspicious about that, where it creates long weekends for employees. And that's where I say, well, you need to have a dialogue and talk to them about, well, are there other days available? Because if Mondays and Fridays don't work for the employer, you don't have to accommodate that if there are other days available. If it turns out Tuesdays and Thursdays are available, perhaps you're accommodating some relief around that. And so you will find you're engaging in rather challenging organizations where you're also going to get a lot of it's none of your business, but it is. If they want accommodation, they need to open up on their own personal privacy issues and disclose. Now, the employer's obligation is not to have further disclosure of those issues except on a need-to-know basis. You don't need to call a full management team meeting to talk about Susie needing to take her mother to adult daycare Monday, Fridays. It's probably something you can address, say, as the owner of the business with her manager to see what you can do about that. And so I've just pointed out this for those of you that are interested in the case law side of it. This is a definition, as I said, that's existed for a number of years now, since 2004. And it was recently supported, and I'm going to address this case in a whole run of cases involving one individual that was just recently dismissed at Supreme Court of Canada level. So this is a solid definition, but the application of it is changing. And so this case is an example of what happens when an employer doesn't have a difficult conversation with the employee and is unwilling to show any flexibility. So in this case, this individual, Suen, was fired when shortly after the birth of his first child, he refused to accept an out-of-province assignment that had him away 8 to 10 weeks. So this was their first child, and he wanted to be there to support his wife. His wife, or the mother of the child, had no medical issues preventing her, or medical, whether they were physical or mental, preventing her from caring for the child. So the employer was scrambling. So this wasn't, again, a nasty employer that's taking advantage of this situation. The individual that had been assigned to this away project had up and quit. So they were left high and dry. They had a commitment to a client. They had to see it through, and they needed this fellow Suen to step up to the plate and take the assignment. So there wasn't a lot of flexibility. And so this case went up and down and all around. So, and it was bundles. I tell you, hundreds of thousands in legal fees, I'm sure. How Suen paid for it, we'll never know. But for sure, the employer was paying out legal all the way. There was a BC Human Rights Tribunal complaint, which was dismissed at the paper level before it went to a full hearing. So that contained costs. That decision to dismiss was then reviewed at the Supreme Court, BC Supreme Court level. It was overturned at the Court of Appeal, and then the Supreme Court of Canada dismissed it and then sent it back to the BC Human Rights Tribunal, and there was a hearing. So it's a little confusing who was appealing what, but it's not really relevant ultimately. What's relevant for you to know is that if your conversations with an employee go sideways or you don't have them, this is what you could be into if anyone digs in. So in this case, there was a lot of talk about, was this a serious interference with a substantial parental or other family duty? And the finding was that he didn't have a substantial parental or other family duty in terms of, would the child be in danger would the infant be in danger if he went away? And the finding was no. Mom was capable of taking care of this child, although those of us that have had children, we're probably pulling out your hair, and 8 to 10 weeks all on your own with an infant is probably a pretty horrific experience to have. But the finding was that there was nothing physically or mentally preventing her from taking care of the child. It was his desire to be closer and to support his wife. So that's great. He was being a present parent. And the decision was, there are many parents that are required to be away from home, and there's nothing that suggests he would not be well cared for. So child wasn't in danger. So it did not meet this criteria of serious interference with substantial parental or family duty. So now that, as I said, went all the way up to Supreme Court of Canada and back to the Human Rights Tribunal before that case was closed. What started this, when the Human Rights Tribunal finally had its hearing, how many years later? So finally had the hearing 3 years later, and this is quick. Like, I've been 6 years just to get to the Court of Appeal. So this is actually a pretty quick trip there and back, 3 years. And so when the hearing occurred and they were able to call the evidence, what happened to bring this about? It was all by email, and often I'm finding by text now. Communication is by text, particularly where our employees are working remotely. So Suen gets an email saying, this is the job, you go on it. He emails back saying no. His boss emails back, says do it or you're fired. They didn't talk. And so that didn't create a legal liability at the end of the day, but it created a whole stream of litigation. And so the outcome of this that is addressed is that hopefully this case stands as a cautionary tale of the insufficiency of email or texting, or abrupt, brief conversations, frankly. So even the conversation won't save you if you're not going to have some open dialogue and some difficult conversations where misunderstandings come into play. The evidence shows that they both became entrenched in their respective positions on the basis of misunderstandings. And one of the issues that they became entrenched about was that Suen was under the belief that it was an 8 to 10 week assignment and he would not be able to go home for that entire duration. And that wasn't the case. When the evidence came out, the employer said, had he asked to go home, we would have accommodated that, even though we didn't have a legal obligation. But he believed he couldn't go home. And that mistaken belief did not come out until 3 years later. So that's really why. And so no, the employer didn't have an absolute obligation to accommodate him coming home, but they said we would have done it. And so that's where often, if you can accommodate, have a progressive workplace. But if it's impossible, have a conversation so that they understand why that's not possible. So another example and there's so many examples, but these are just a couple of recent cases, is childcare and the duty to accommodate. And again, we're seeing this heightened with COVID, where we've got employees saying, well, I have a COVID leave. I've got a child that's been sent home from school. I don't have daycare available, or the child's been sent home from daycare, or my daycare's closed, I have a childcare issue. This one is the more conventional childcare issue, which is over daycare following a maternity leave. And so this is happening more and more frequently. And those of us that are in small communities with limited access to daycare, now even in the Lower Mainland, when I worked and lived there I was in Vancouver, 1993 to 1999, it was horrendous trying to find daycare. And so this is an ongoing issue, trying to find daycare. And so we have these cases where we've got employees who are going on maternity leave, can't find daycare, and need to extend their leaves, their maternity or parental leaves. And now, one of the learnings from this story, when I get into it, is the importance of an employer to get involved. It is your business about what steps has that employee taken to secure daycare at the time the employee's pregnant, not 2 months before the employee's returning to work. Often daycare lists are 12 months, 2 years, 3 years long. So your employee, particularly if it's a first child, may have no idea that finding daycare is mission impossible and they're going to have to get on lists. So, a lot of employers don't want to talk about the pregnancy. You don't want to look like you're treating somebody differently. It's none of your business. Daycare's your business because your employee can't work unless you address that. So in this case, this woman had worked, at Pacific Blue Cross for around 11 years. And then she quit because she was told on returning, so she had daycare, but there was a change in the workplace. So while she's on maternity and parental leave, her shifting changes. And so she had secured daycare. But then she finds she's just back from maternity parental leave and her shifting is changes, and the daycare she secured would not, on a couple of days a week, allow her to get to the daycare to pick up by 6 o'clock. She wanted institutional daycare. She did not want home-based daycare. There wasn't anything closer or available. The employer offered to delay her change in shifting. She was a team lead. Sometimes an employer can't delay if your change in shifting is, say, a manufacturing environment, but she was a team lead, so they could do some flex around her delay in shifting. They offered her a further 1-month extension to resolve childcare issues, and she quit. She just said, no, I'm not going to do it. And she did secure employment closer to home, which saves. Didn't, in this case, the employer was successful, and I'll explain why in defending this human rights complaint. But if you were unsuccessful, you're potentially paying lost wages. So in this case, she had secured another position. So she still was angry enough and upset enough to file a human rights complaint. And so this case boils down to not only dialogue, but also pushing some responsibility over to the employee. And again, this case illustrates a bit of the philosophical, moral, ethical views around parenting and the arm wrestling that you can get into that with an employee. Ultimately, this case, and there was a couple of trips at the Human Rights Tribunal, ultimately, in this case, the complainant was not successful because she did not look at other daycare options. And she didn't look for other daycare options because she knew in the areas closest either to her workplace or her home, there was no other institutional option. She had the one and only. So similar to us in Vernon, like this institutional type daycare, our big one is our Maven Lane. And so she'd said, well, I don't need to look for anything else. I know it's not available and I don't want home-based daycare. So she actually lost this case because she wasn't willing to consider home-based daycare. So this is where I'm saying, I think we're going to see some evolution in the law in the employee's favor as time goes on. So where you have a parent that has a very, very strong fundamental belief about how effective or safe the care of the child will be, whether it's institutional or home-based daycare, 5 years from now, this case, even now, this case could have gone another way. But basically, she made insufficient efforts, and her statement was, well, why go to an effort when I know there's nothing there? The next failing was that she was not prepared to consider non-corporate home-based daycare as a possible solution. Now, the tribunal was sympathetic to that. Many parents might react similarly, but what they said is you you still should have looked at that. And so she's ending up being caught between a rock and a hard place, and her complaint was not ultimately successful. But again, the employer had to put a lot of energy into dealing with this. So it's really important to have these conversations with your employees, you know, in their pregnancy, during their leave, not just one, find out what they've got lined up, what are their plans, what are their backup plans if that falls through. And again, if your workplace and work environment changes, terms and conditions of work change, shifting changes, and that could impact daycare, let your employee on leave know ASAP so they can possibly flex also.
Yeah, I had a question come in, Veronica.
Sure.
So it's from Val, and she says, I get the fact that the employee needs to find daycare, and I understand it is in the interest of the employer to know what the daycare plans are. My question is, at what point does privacy come in if the employee feels they are being asked too many questions about a personal matter?
Yeah. It's contextual, is that if the employer needs to understand what the issues are in order to accommodate, the employee is giving. I'm not saying that they have no right of privacy, but they need to flex a little bit on that. And so part of the conversation needs to be about, I think, to let the employee know where these conversations are going and who they will be shared with. But part of that, I think, lies in educating the employee to say that the employer, is not legally required to accommodate this request unless we have a better understanding of what it's about. But it is a challenge, Val. Like, I find that where we're trying to accommodate employees with disabilities, where we'll say, explain to us the nature of your disability. Don't need the diagnosis. We don't need to know you have Parkinson's or MS or AIDS or this or that. What we do need to understand is, do you have, like, what's restricting you from doing your job? So you need to know if the employee has sleeplessness, if they have tremors, if they have difficulty standing. So you need to know, but often we'll get notes from doctors saying, confidential, not telling you. And so sometimes then I actually prepare a formal letter to go to the employee that educates them. And I've even directed them to resources where I've said, go have a conversation with CLASS, the Community Legal Assistance Society, which provides advocacy, representation, and education to individuals with human rights complaints. I'll say, we're right on this. Go here's an organization that exists for your benefit. You go talk to them and see what they have to say. So often I try to get into the education. And in the family and daycare childcare issue, the employee may also be struggling with a child with special needs. So they may be saying to you, well, I must have a certain type of daycare, but not want to tell you that perhaps their child was born with mild cerebral palsy, or perhaps their child, I had a child that was so acutely hyperactive, he couldn't actually function in any daycare environment. I had to retain and bring in a private nanny, which meant I needed time to go through the process, to bring in someone and go through an immigration process to bring in a nanny. And so your employee may be reluctant to talk about what's underlying those issues. So I really think it's important the employer create a safe place for them to have that conversation. And what you'll often hear is, oh, we want you to have witnesses. And, I'm flex on that, is that your primary responsibility is to create a safe, emotionally safe place for your employee. And if that means you're going to take a chance and have a one-on-one conversation outside the workplace, having a walk in a coffee shop, in your office door closed, no one there, exercise judgment around that. Help the employee feel safe so they can actually say to you, this is what I'm struggling with, and this is why Maven Lane won't work, and so often employees will disclose if they feel safe or if they're informed or educated. And then ultimately, if they won't disclose, you can put your foot down and say, I won't accommodate. So, and I had 2 or 3 other childcare related cases, and one of them was about an employee that's like, no, I'm not telling you why. And she filed a complaint, and the employer said, never told us why. We asked. She said, none of our business. So she lost, but you still had the human rights complaint. So any other questions? I've got my takeaways here, but you can all see those. So, and that addressed around Val's question of, well, what do you do if you can't extract that information? Oh, I want to talk about this last one. Explore what the employee has done in terms of reasonable efforts to find reasonable solutions. That goes again back to the Ziegler case, is that it's not all on the employer. The employer's responsibility is to drive the conversation, which seems a little crazy when the employee is asking for the accommodation. Once you're aware that the employee asks, or it's fairly apparent without them asking, it's the employer's responsibility to drive the dialogue. But the employee has a responsibility not to be stubborn. And the employee also isn't entitled to what they want. They're entitled to a reasonable solution. And the employee does need to disclose their efforts. So yes, I've had it where I've coached clients to say, well, you need to find out what daycares they've looked at, get them to give you a list. You want confirmation they're on wait lists. Go get confirmation. You know, if they've said I'm on the wait list for, you know, Maven Lane, House of Dwarves, this or that, then say, you send me a letter. Like hopefully you're not that polarized, but it might come to that, to say, I want proof of confirmation. Sometimes employers become experts in searching for daycare. I've had clients where I've said, well, again, it's first child. They might not have a clue. They might know the obvious, but do they know you can go to Childcare Resource and Referral here in Vernon, which is sharing a building with the Boys and Girls Club, and they'll give you a long list of licensed and unlicensed daycare. And then you might have a conversation with the employee. Well, they'll say it's unlicensed, it's unsafe, which doesn't mean that. It's an unlicensed daycare is a regulated daycare that has restrictions on how many children are allowed to be in the care of the caregiver. So licensed has restrictions too. So it's a bit of a misnomer. But I have talked, just like you're dealing with an employee, say with addiction issues or gambling issues or mental health, you might find you're Googling different resources because you want your employee to get well and the doctor isn't seeming to provide direction. So sometimes you're doing some of the homework the employee should be doing. But then you can say, look, I gave them a list. I told them to go Childcare Resource and Referral, and they didn't do any of it. So I am finding clients are having to accommodate longer leaves because of difficulties with daycare. But I truly believe that if the employees were getting on wait lists at the time they got pregnant, they probably wouldn't have to be waitlisted at the expiration of an 18-month leave. And so I've gotten into this. The employee can't dictate because of family-related desires or preferences, nor can they dictate the level of accommodation. They might ultimately get what they want because after exploring it, that's all that's available. And you may be legally required to accommodate, disrupt your workplace if it results in a serious interference with a substantial parental or other family duty, and there's no other reasonable alternatives. So, but again, you need to have dialogue around that. So there you go. I have no idea how I am for timing.
We're bang on, Veronica. Yeah, you nailed that. We're just before noon. I don't see any further questions, so you must have done a really good job explaining, and you were quite thorough. So
we hope so.
Thank you so much for your time. We really appreciate you being here and sharing your knowledge and expertise with our members. It's greatly appreciated.
Thank you.
So, yeah, thank you again, and thank you to all of our members for attending. And we appreciate you so much. Hope everybody enjoys the rest of your day.
Thank you.
Take care.